In a series of its first proposed laws, the Carney government seems to be targeting essential rights and freedoms long valued in Canada. Threats are Bill C-2, which the government labels the Strong Borders Act, Bill C-8, which it calls the Act Respecting Cybersecurity, Bill C-9, which it named the Combating Hate Act, and the strange Bill C-12, which duplicates elements of C-2, and which it calls Strengthening Canada's Immigration System and Borders Act. While these may appear as unrelated legislative proposals and changes, they are not. They form a broader picture of restrictions on privacy, expression, and civic participation essential in a democratic society. Why is the government doing this? Much less a Liberal government recently elected for its elbows up stance toward Trump and to stop the election of an unpopular Conservative leader who now has a dilemma, as these bills reflect much of what his party has advocated. Are there better alternatives? What can be done to uphold Canada's respect for privacy, freedom of expression, and openness to civic participation? We have an impressive panel that's going to address these questions. I'm Jim Turk, the director of the Center for Free Expression, and this evening we are going to discuss these unprecedented series of bills. But before we introduce our panel, I want to acknowledge that the land on which I am speaking to you tonight is the traditional territory of many nations, the Mississaugas of the Credit, the Anishtabek, the Chippewa, the Haudenosaunee, and the Wendat peoples, and is now home to many First Nations, Inuit, and Métis. I also want to thank PEN Canada, who is co-sponsoring this conversation with the Center for Free Expression. And now our panel. Karen Cocq is the co-executive director of Migrant Workers Alliance for Change. Welcome, Karen.
Hi, Jim. I'm happy to be here.
We're delighted you are. Our second panelist is Tamir Israel. Tamir is the Director of Privacy, Surveillance, and the Technology Program for the Canadian Civil Liberties Association. Welcome, Tamir.
Thanks so much for having me on, Jim.
We're delighted. Our third panelist was going to be Anais McNichol, who is the Director of the Fundamental Freedoms Program at the Canadian Civil Liberties Association, but she's quite ill this evening and is unable to join us, so I'm sorry that she's not going to be able to be with us. Our third panelist then tonight is Tim McSorley. Tim is the National Coordinator of the International Civil Liberties Monitoring Group. Welcome, Tim.
Thanks a lot, Jim. Great to be here.
And our fourth panelist is Rizwan Mohammed. Rizwan is Senior Advocacy Officer, Government Affairs and Public Policy with the National Council of Canadian Muslims. Welcome, Rizwan.
Good to be here. Thanks.
And our moderator for this quite remarkable group of panelists is Matt Hatfield. Matt is the Executive Director of Open Media, Canada's leading community-driven organization that works for an affordable, surveillance-free, and democratic internet. Welcome, Matt.
Hi there. Thanks for having me.
So I'd like to just explain to the audience. So we're going to have the panelist is going to have a conversation about the issues that I mentioned. It's going to go on 45, 50, 55 minutes, and then they're going to turn to you, the audience, for questions that you might have. In this version of Zoom that we use, the chat is not opening, but there is not open, but there's a Q&A button. If you look down at the bottom of your screen, you'll see a Q&A button. And so when you're listening to the conversation, if you think of a question that you'd like to ask one of the panelists or ask all of them, just click on that button and write down your question as you think about it. You don't have to wait till we turn to the audience portion to do that. So just do it as you're listening. And then Ange Holmes, who's the coordinator for the Center for Free Expression, will be monitoring the questions. And when Matt turns to the audience, he'll ask Ange for the first question, which she'll read out. The panel will discuss it. And then the second question, so forth. Please take advantage of this function. We have such important issues and we have such an impressive panel. It's a really good opportunity for a conversation between those of you in the audience and the panel. And we hope you'll take advantage of that. That's all for me. So at this point, over to you, Matt, and the panel.
Great. Thanks, Jim. So, we're going to be talking about 4 different bills. And I think for any ordinary member of the public who has other things to do with their time, keeping up on one bill is a lot, let alone 4. So we're going to start by doing just a little bit of a go around of what's going on, the basics with each of these pieces of legislation. And we're going to start with Bill C2 and Tim.
Thanks, Matt. Yeah, I'll try to keep this brief, but I know there's going to be a lot to talk about both on this bill and others. But so Bill C2 was introduced by the government back in June as their very first piece of legislation of this new government, and it really set the tone for I think what we're talking about tonight, because it's an omnibus bill that comes in at like 140 pages and makes drastic changes to a whole slew of existing legislation, creates new acts, is ostensibly the government's response to Donald Trump's tariff threats and getting rid of those by protecting our border. But really, at the end of the day, it goes much further by bringing in things that we know the government and law enforcement and intelligence agencies and the immigration and refugee department have been trying to bring in even before there was any word of Trump and tariffs, and that really threaten fundamental human rights and the charter rights of people in Canada. It would impact the changes to Canada Post, to the Coast Guard, to money laundering and anti-terrorist financing laws. But the most worrisome and that I think many of us have been working on are really those that are fundamentally attacking privacy and the privacy rights of people in Canada, as well as attacking immigrants and refugees and the systems that are put in place to uphold their rights. So maybe just really briefly around what the privacy threats are. So it would create new requirements that will allow new powers to allow police without a warrant to ask service providers to provide revealing information about Canadians and the services that they use without requiring a warrant, about when we use it, where we've used these, how often we've used them, which is very highly revealing. And then based on that they could more easily seek out warrants to get information about the about what's in those accounts, account numbers, more information about use and the services that they've provided. So for example, and this is any service provider. So for example, if you access a healthcare survivor or mental health provider, the government would be able to ask, have you accessed them? Why, when, and other questions like that. These new powers would also be extraterritorial, so law enforcement and intelligence agencies would be able to request information from service providers outside of Canada. And it would also create new reciprocal powers for foreign law enforcement and agencies to request private information about people that's being held in Canada, about people in Canada, and have their requests enforced by the Canadian justice system, including in instances where even a crime that they're investigating wouldn't be considered a crime in Canada. And so it opens up people to all kinds of abuses in other jurisdictions that might not have, the same kind of rights protections that we have here in Canada. In terms of information sharing, it also would make really drastic changes to information sharing for the Immigration and Citizenship and Refugee Department, where they would be able to more easily share information with departments across all levels of government in Canada, including provincial and territorial governments. So being able to share information about any information that they hold about migrants, refugees, and Canadian citizens, because it's also passport information, and share it with other healthcare providers, welfare providers, that could be used to shut off essential resources for people and services for people without them knowing that that's how their information is being used, and it could even be shared with foreign agencies as well. And so we know that people are coming to Canada to escape, attacks, persecution and attacks, even though we know that that still happens in Canada, but people are looking for greater protection here. And the information they provide could even go back to those same governments. And then the very last thing I'll mention is that it would also allow for new rules that would force electronic service providers, Google, Facebook, Signal, WhatsApp, Meta, and others, to change their systems in order to facilitate government surveillance. So either through public rules or secret orders, they would be forced to maybe collect more information and retain data that they wouldn't normally in order to allow government to access it down the road. And there's even questions about whether or not this could be used to undermine encryption and create backdoors in encrypted communications. The government says no, but from many people's reading of the legislation, it really appears that that is a a likely outcome. So I know that's a lot. I'll end it there. But just to say that it's a fundamental attack and really sets a tone. We had a government saying, elbows up, we're going to fight against Donald Trump, we're going to protect your charter rights, we're going to protect your freedoms. And then the very first bill is one that completely undoes everything that they've said and really shows that the rhetoric was just that.
Thanks, Tim. That's a great overview. And I think a thing that many people in our community have been confused about was exactly what the relationship is of C2 to C12 and what's in C2, what's in C12, does C12 replace C2? Maybe Karen, you could speak a bit to that and what it isn't C12.
Yeah, for sure. Thanks, Matt, and thanks, Tim. So like Tim said, so C2 was introduced in June of this year as the first piece of legislation, and it included, all of these different elements. And there was effectively immediate and very vocal pushback from across all sectors of civil society. So, basically everybody on this screen and. And so there were all sorts of public statements and letters and stuff that were springing up all over the place, one after another, in opposition to various elements of C2. And so we had a press conference, a number of us on the screen in June to respond and about the attack on the rights of all people that are living in this country, whether they have citizenship or not. The government responded not long after, in October, actually, came back with another piece of legislation saying, okay, we've listened, and there are concerns around the privacy elements. And so they didn't withdraw C2. They introduced a new bill, C12, which is Protecting the Integrity of the Immigration System and Borders Act. And they basically took the pieces that were immigration, not just immigration, but mostly immigration related in C2 and copy and pasted them into C12, but left it all in C2. So it's kind of C2 still has all of the original pieces, and then C12 has some of the pieces. And the main components, and the reason why they did that is because they said that they thought that they were listening to Canadians around the concerns around privacy and the information sharing and all of that. And so they wanted to give C2 time for further, more in-depth study, whereas they thought that all of the immigration pieces would be easy to pass quickly. And so they pulled those out into a separate bill. And I think that says a lot about the political context that we are operating in right now in Canada, that they thought that they were really taking a gamble that attacks on migrant and refugee rights would be an easy sell, effectively, was the strategy, the legislative strategy with C12. So C12 includes not just immigration stuff, it includes some stuff with the Oceans Act and empowering, the Coast Guard to search boats and things. And there's also an important piece that I wish we had somebody on this panel to speak to more eloquently than I can around changes to scheduling of precursor drugs in the Controlled Drugs and Substances Act, which is ostensibly about cutting back on or trying to address drug trafficking, but in fact would probably make the toxic drug supply crisis in Canada that much worse. So that is an element that is in C12 as well. But the pieces that I can speak to are the immigration pieces, and there's four main components to that. The first is that C12 would give Immigration, Refugees, and Citizenship Canada the ability to be able to enter into information sharing agreements with all other levels of government, like Tim was saying. And so this is something that is concerning for the reasons that he said, around being able, because it includes also all crown corporations. So that means people would be able to notify, for example, the government would be able to notify someone living in co-op housing, for example, that is run by a municipality, for example, about the immigration status of the person who is living there. So there's concerns around the information sharing piece, especially because it involves sharing information with foreign entities. And specifically when we were talking about people who have migrated to Canada, that is a very real concern around information getting into the hands of people whom people have been fleeing. So there's the information sharing piece. The second is putting a 1-year limit on being able to file a refugee claim. So saying that as of 1 year from the first time a person has entered Canada, they can no longer file a refugee claim if more than a year has passed from their first entry into Canada. This is really significant because there is no such time limit or time frame placed on the right to claim asylum in international law. And there's a reason for that, because conditions change, personal circumstances change, and you cannot start a clock on expiry on somebody's need to seek safety. So there's the 1 year bar on asylum claims. That's the second piece. The third piece is people may not be familiar, but there's the Safe Third Country Agreement is an agreement that Canada entered into with the United States many years ago that basically said that no one coming from the United States into Canada can file a refugee claim, because if they first arrived in the United States is a safe country and they should be able to file for refugee status there. This has long been a highly disputable fact, but even more so now as we see what has been happening under the current Trump administration, that it is simply not possible and justifiable to be able to say that there are all categories of refugees that are simply not safe to file claims in the United States. So that agreement says that, but there was an exemption to say that if you crossed between official ports of entry, so not at an airport or not at a port or at a bridge, for example, and remained undetected in the country for 14 days, you could then file a refugee claim if you came from the United States. Bill C-12 proposes to close that exemption. So this is about the motivation is about trying to get at things like the existence of the Roxham Road crossing that in Quebec that from a few years ago that maybe people are familiar with, right? To say that people shouldn't be incentivized, quote unquote, to cross on foot, when in reality what it is an essential and necessary life-saving mechanism for people who cannot claim asylum in the United States and have no other option but to come to Canada irregularly. That's the third piece. The fourth piece is C-12, and this is entirely new in terms of what currently exists in the Immigration Act. C-12 would give the Minister of Immigration or the Governor in Council, as it's known, the power to cancel or change or suspend the immigration applications or documents of masses of people, en masse, so entire groups of people, from one day to the next, no individualized assessment, and no right to appeal. So this ability, this power, this discretionary power in the minister's office or the governor and council has not existed since the early 1970s because it drew such criticism and international shame, actually, that the Canadian government could make blanket statements like, no one from Haiti is allowed to come to Canada, end of story. Or anyone here who is a woman gets their immigration papers taken away. That is the nature of the discretionary power that C-12 gives for mass cancellation. So those are the kind of main elements on the immigration side.
Thanks, Karen. Listening to all this, I really wish that I could tell our listeners that all of this started with the Trump era and with Carney's response to it. Unfortunately, some parts don't. And so I'm going to speak to Bill C-8, the Cybersecurity Act, which initially was introduced as Bill C-26 in the last parliament under Justin Trudeau. Came very close to passing in that parliament. The only reason it didn't actually is that there was a legislative error that was discovered very late on. So it died at that stage before the parliament, as the parliament dissolved. So what is Bill C-8 about? I think its origin point is dealing with situations like the Huawei infrastructure that is in some parts of Canada and that many of our allies have decided they want to see stripped out of their telecom systems. The government is looking at situations like that and wants to have more power to issue orders to telecom companies in those kind of situations. A lot of countries we're allied with are concerned that Huawei could be used for espionage purposes against Canada. Some Canadians worry about that as well. And I think the concern that partly guides C-8 is that currently telecoms could really drag their feet in those kind of situations. It costs them money to remove that kind of stuff. They can downplay and minimize the problem. And we've seen a few times in recent years where much smaller versions of this problem, like the Rogers outage people remember from a couple of years ago, or like some of the storms on the East Coast, telecom services have been disrupted for days in Canada, and the government's actually found it quite difficult to get responses from telecom companies or to issue them orders on what to do or not do in those situations. So there potentially is a legitimate purpose for reform around cybersecurity and for having some emergency powers there. But C8 goes much, much further than I think most of us would think would be a purely legitimate purpose. The government has awarded itself extremely broad powers to order telecom companies to do or not do different things, both in an emergency, but also continuing well past any reasonable emergency. The minister can order telcos to install equipment in their networks that the government selects, which could be used to intercept our private communications. The minister can order particularly people or devices in Canada permanently disconnected from Canadian telecom networks without explanation, without any redress for those people. Now, that might be okay if it was aimed at like a foreign hacker of some sort, but there's a huge risk that ordinary people in Canada with devices that have been compromised could be caught up in that kind of situation and really have no ability to figure out what was going on or get themselves back on the internet. And I think even more fundamentally, there's just no built-in review of what the minister is doing or decides to do. We don't have a judge weighing in, and the government can actually keep the orders that the minister issues to telcos permanently secret. And so you have secret orders building on top of secret orders. There's an enormous risk that over time we're essentially building a whole secret surveillance system in Canada legally under Bill C8, but really in contradiction to the legitimate purpose of the bill or what most people in Canada would want to see. That's a nutshell in C8. We're going to talk more about it further, but I want to hear a bit about C9. I think Riz, you're going to guide us through there.
Yes, thanks, Matt. Thanks to Jim and everybody at the Center for Free Expression at TMU for having us. Great to be on this panel. So C9 is a bill, is a piece of legislation that the Ministry of Justice brought forward in September 2025. It's been making some progress through the House of Commons, and it's at committee. It's being studied. There's been a number of experts that have spoken to concerns around the bill, including the National Council of Canadian Muslims, the NCCM, of which I'm a part. What I'll do is talk about 5 pieces that the bill has, say a little bit about what the government's trying to do there, and then sort of comment a little bit about some of the concerns that these pieces raise from a civil liberties perspective. So this bill is called an Act to Amend the Criminal Code, Hate Propaganda, Hate Crime, and Access to Religious and Cultural Places. It proposes to do about 5 things. The first is to remove the Attorney General consent related to hate propaganda offenses. This is something that, the government has been looking at in terms of, they've been hearing from different people say, this AG consent was, placed as a safeguard, as a guardrail against overcharging, against abuse of this, but it was done pre-social media and pre kind of some of the more recent examples in the last decade or so that we've seen of violent hate on the ground and online. And so they proposed removing the Attorney General consent as a way to make the law more responsive and more flexible to address things that seem to be clearly violent acts of hate. The second piece of the legislation suggests or proposes to create an offense for willfully promoting hatred against any identifiable group by displaying certain symbols in a public place. And when you actually read through the bill, what the government's kind of pointing to here and where this is kind of coming from is that in certain public spaces, online and offline, people have been displaying Nazi Hakenkreuz symbols or SS symbols. We've seen them at different kinds of protests along the political spectrum. Sometimes you've seen them like a full-out Nazi flag being waved at a demonstration. In other cases, we've seen posters where the Nazi Hakenkreuz is on a poster with the Nazi Hakenkreuz equals the flag of a certain country, namely Israel in that particular case. And so the government is attempting to respond to things like that. There's some issues with that I can get into in a moment. The third thing that the government's proposing to do is to create a new standalone hate crime offense so that, for example, if somebody were to commit a violent assault and evidence pointed to the assault being hate motivated, that police would have a tool in the criminal code to lay an assault charge and a hate crime charge at the same time. Currently, we can't do that in those kinds of cases. So for example, when Alexander Bissonnette um, engaged in a mass shooting at the Quebec City Mosque some years ago, he was charged with murder, first-degree murder, but not charged with a hate crime or a hate-motivated murders. So that's one thing that element, that third piece would attempt to address. And then the fourth thing is the bill proposes to create an offense of intimidating a person in order to impede them. In other words, block their access to certain spaces that are primarily used for religious worship or by an identifiable group for certain purposes. In other words, the government's saying they've seen, for example, uh, places of worship and cultural spaces, whether they are Jewish synagogues or LGBT cultural spaces. If they're hosting, for example, an event celebrating something to do with trans life, for example, they've seen protesters come. The government claims that they see examples where access to those spaces was blocked unlawfully, and so if this is being done in a way, they're saying um, intimidating people from being able to access their place of worship or their cultural space or community space on the basis of their identity, that this part of the legislation would address that challenge. And then the fifth part is creating an offense of intentionally obstructing or interfering with a person's lawful access to such places. So there's the intimidation part, and then there's the obstruction part. Now, while we can kind of appreciate where the government's coming from this, especially as Canadian Muslims, and as when we hear from Canadians that on the basis of their identity are disproportionately targeted for hate, Statistics Canada reports in its annual police reported hate crimes data that in terms of people that are disproportionately targeted on the basis of race. We see Black and Indigenous people the most targeted on the basis of their sexual orientation or sexual identity. LGBTQ people are disproportionately targeted on the basis of religion. We see Canada's Jewish community and the Muslim community disproportionately the most targeted. There's other levels here, but I'm just mentioning the top two or three in the different categories. So from that perspective, we've been at roundtables, stakeholder consultation tables for over the years, trying to push the federal government, push different levels of government to take more action to combat hate. So we can appreciate that this is coming from a place to respond to community concerns, but there's a number of really deeply concerning aspects of this from a civil liberties perspective, and I'll name a few. The first part, in terms of removing the Attorney General's consent requirement, related to hate propaganda offenses has potential risks that may play out in different ways depending on the specifics of each case. But they include concerns regarding accountability and the increased likelihood of inconsistent enforcement and politically motivated prosecution. When we think about the ban on hate symbols, this is actually when you go into the details of the bill, it's banning hate and terror symbols, and it ties it to the terrorist entities lists under the Criminal Code of Canada. If you look at the terrorist entities list, about 90% of those listed entities are somehow connected to or affiliates of ISIS, Al-Qaeda, and other similar Muslim extremist groups or violent extremist groups that hijacked the Muslim faith. You also have a handful of Sikh groups, and you have a handful of white supremacist groups like Adam Waffen and Combat 18 and things like that. Um, those were more recently updated in the last few years. But that terrorist entities list ends up relying on symbols that, where these extremist groups have Arabic language on a lot of their symbols. And you create a situation where um, you could risk criminalizing communities for simply displaying a religious or cultural symbol that's been hijacked by a listed terrorist entity. For example, the Muslim testification of faith, La ilaha illallah, Muhammad Rasulullah in Arabic, no God but one God, and Muhammad is the messenger of God. That appears on many countries' national flags. And it appears in scripture, it appears in mosques, but it also has been hijacked by ISIS. ISIS's flag has that. So it could risk criminalizing a community for simply displaying a religious symbol. Um, if a police officer interprets that symbol as vilifying a group. Especially problematic sections of the bill include subsection C of clause 2.2. If you look at the willful promotion of hatred part, that clause notes that even displaying a symbol that so nearly resembles a symbol associated with listed entity through, quote, confusion, the word confusion is used, that could be confused with, that could also be deemed illegal. So now you have the bill introducing really over ambiguous language around resemblance and around confusion. And we can get into that a bit more. I won't say too much about the creating a standalone hate crime offense because NCCM has been in favor of it. I welcome other panelists to speak to any problems that are related to that. But Section D, creating that intimidation offense, there's a risk to criminalize anything with the intent to provoke a, quote, state of fear in another person. So that raises concerns around enforcement. How do you assess a state of fear and legislate related to people's fears rather than like looking at action like violence or specific actions? And then the last section, Section E, the creation of a new standalone obstruction offense, we think risks duplication, overcharging, and disproportionately impacting marginalized groups. So if you look at this holistically, the primary issue with this bill is that it was brought forward without like adequate consultation with the affected communities or other civil society experts. Some, including some on this panel, have spoken to this at committee, but very little consultation on all these aspects. If some of these aspects were talked about beforehand, I can point to different groups that could say, we heard about 2 of these, or we heard about 3 of these. It wasn't presented as this package, and fulsome consultation was not done on this whole package of how this bill is actually coming forward. Furthermore, the bill would carry troubling implications for charter-protected freedoms, including freedom of expression. Instead of safeguarding charter-protected rights, the bill risks suppressing legitimate criticisms, silencing individuals who seek to exercise these fundamental rights. It risks, as the CCLA has eloquently put it, criminalizing protest activities of many different groups across Canada. And I'll stop there.
Rizwan, I think you're anticipating where we're going to go from here. So now we're going to get into a bit of a back and forth conversation. People have just learned a huge info dump. They've heard about a lot of different bills. What I would like us to do is take this, 250, 300 pages of legislation and pull out some of the common themes we're seeing across several of them so people can remember both common problems amongst legislation Canada's considering. And maybe we can talk a little bit as well about where we think this comes from and why the government is doing all of this. So if people can unmute their mics and just jump in here, what's a common theme that one of us would like to highlight here?
I think one thing that does jump out pretty quickly is the lack of consultation and the often rushed process, with which these bills are being presented. We saw this in Rizwan mentioned this regarding C9, and it's been even more pronounced, I think, with C12. At C2 initially was, I think, the plan was to introduce. I mean, it was introduced 2 weeks before the summer recess, and I think the plan was almost to maybe pass it, the entire bill at some point, like before the year end, and that didn't go all the way through. But we're seeing with C12, which has many of the, maybe the most problematic elements of it that are being rushed through Parliament. They're not hearing from groups who are impacted by this on C12 in particular, and on some of these others to some degree. Elements of these bills don't even don't even almost make sense in some ways or are counterproductive. I mean, we see this with C8, where like elements of the bill could be used to, C8 is supposed to be protecting cybersecurity, but elements of it could be used to undermine cybersecurity. And this is a pretty big flaw in a legislation regime that's supposed to protect cybersecurity. But it's hard to get the government to listen and to address these flaws. And same with C12. You know, C12 is being presented as a way of improving the integrity of our immigration system, or parts of it are, but I mean, elements of it could, in addition to really disregarding the rights of the people that are going to be impacted by this, elements of C12 could be there's a serious concern that elements of C12 are going to make some of the backlogs that we're seeing in our immigration system even worse, because they're going to push decision making to low quality decision makers and just create backlogs in different places while still disregarding the rights of all the people that are being shoved aside.
Yeah, I think the consultation point is so interesting because the government will sometimes say, you're just going to critique whatever we do anyway. We're just going to get our ideas out there. We've got talented people. We've spent the time to build this appropriately. Usually they have not. And when they do take more time to consult, they do produce better legislation. Many of us were involved in both round 1 of online harms legislation from the government and round 2 of online harms legislation. And round 2 wasn't totally ready to go, but they consulted really heavily in writing it, and it was much, much closer to appropriate legislation. It actually had a lot of support and could have passed in the longer parliament. Sorry, someone is going to speak.
Maybe just to add to what Tamir was saying about rushing through legislation, one of the things we're not talking about today was also Bill C5, the Major Projects Act, that they did put closure on and essentially passed it within a couple weeks, despite the opposition of indigenous, environmental, climate justice organizations. And that, there's the issue of the lack of consultation and the lack of involvement, but it's also, I think, a theme of like shutting down both being able to being involved in the preparation, the formulation of this legislation, the discussion of it, but then with things like C9, with things like aspects of C12, with the information sharing powers and ability for police to seek out information, and just the chill that it's seeking to create also in opposition once these bills are adopted, I think really is an overall kind of push to undermine the democratic process and freedom of expression and being able to push back on this legislation. Even, the aspects around immigration refugee changes, it's not explicitly about freedom of expression, but when you know that your information is being shared, when you're struggling and are facing, the threat of a mass deportation or mass cancellation of status, and as we've seen in the United States, it's been mass, but also could be targeted, so that people who are political opponents of the government could be told, well, we're going to just cancel your permanent status in Canada and you're going to be deported. And so it's about all, I think that they're fundamentally undermining all stages of being able to give input before a law is there, being able to participate in the parliamentary process, but also being able to act outside of parliament and push and fight back against these kinds of legislation. And I think that's really, really troubling and something that, I know many of us have been talking about, but I don't think has really, hit the public in terms of what the overall impacts of some of this legislation is going to be.
And that's kind of shared procedural problems. Oh, sorry, go ahead, Karen.
Oh, no, sorry. I would echo what Tamir and Tim said about C12, but I think another element as well in that is, and I'm not sure how kind of seamlessly this maps onto all of the different pieces of legislation, but for sure to some degree there's this kind of concentration of power and a real a shift to very discretionary power. So I know Rizwan talked, about some of that with C9, and for sure that happens. That is the case with C12. Is a real a concentration of discretionary power in places that are not actually subject to oversight, that are not subject to any kind of parliamentary kind of oversight or process. They're just really people making decisions. And Tim brought up the example of C5, which is a bit different, but a similar pattern, I think, of the creation of the Major Projects Office, which is kind of this extra legislative entity that is going to be making a bunch of decisions that are that the legislation empowers, but that it is not itself a legislative body, and so it kind of puts it out of reach of any of some of that oversight. And so I think that kind of wanting to rush things through and then really concentrating the power to be able to make decisions and to be able to implement the powers and the changes that these pieces of legislation provide the government with very little kind of check or countervailing kind of oversight.
Yeah, if I
Yeah,
can
and
jump in there.
sorry.
Sorry, Matt, you go ahead.
Well, I think that element really comes out in C8, where there's sort of a false argument the government will make. Well, there's an emergency situation. The minister has to do something right away, and there can't be any review. It has to happen in secret. It just has to happen now. And we're not arguing that point. Yes, you can do that, but what should happen if the bill is really intended to accomplish purely its stated purpose is that you have later judicial review. So the minister makes the emergency decision. Something does happen in secret, perhaps for 20 days, 30 days. And then a judge comes in, reviews the decision, it's eventually published, and the judge says, yes, this was in keeping with C8's described purpose. Or no, it wasn't, there was a problem here, and the minister can't do this going forward. And that's the kind of check and balance that is really lacking in a lot of this. Rizwan.
Yeah, thank you. I think just continuing along the theme of this problem of removing checks and balances, I mean, from one angle, if you were just looking at offenses that were much clearer violent acts of hate, that we could point to specifically, removing the Attorney General consent around those kinds of violent acts of hate, you could understand. But what they're proposing is removing the Attorney General consent to proceedings related to hate propaganda offenses. What ends up being hate propaganda? And how is that going to be determined? Who is going to determine it? This looks like we're removing a check that could balance some things out. We kind of also talk about the common element of fundamental freedoms in the charter not being respected across the board here. I think C9 illustrates that very clearly. I spoke to some of those things. I think when we talk about free expression, we also need to talk about freedom of assembly and how the chilling of the freedom of expression can also be tied up with and bound up with chilling freedom of assembly when you start to disrupt lawful protest activities with legislation that goes too far in this kind of case. Another thing that's maybe more subtle and we could more arguable is that, for example, how religious freedom and expressions of religious freedom may be impacted by this. So, for example, a couple of years ago, the Bloc Québécois had introduced a private members bill to actually amend the criminal code to remove the religious defense from incitement to hatred. There was, a famous Supreme Court case, like R versus Whatcott, that had kind of made a distinction between, messaging that was communicating something that was maybe in a religious scripture and incitement to hatred, and calling for somebody to be discriminated against on the basis of their identity. And that idea was actually being discussed. Some of the members of the Justice Committee, while questioning witnesses about Bill C9, actually started asking those questions. Now, they weren't proposing that be baked into this bill, but they were kind of asking witnesses questions about, well, how would they respond to this? Why would religious defense need to stay in there? So I think freedom of assembly and some other fundamental freedoms are also implicated. So we can kind of see actually broader charter implications here across the board.
Mm-hmm.
Yeah, and I think, with the removal of like this sort of, it's a combination of like sort of vaguer restrictions and fewer safeguards in place. So like with C9, for example, I mean, a lot of this is going to be really decided by law enforcement on the ground at political protests in some contexts. And that's a very, maybe the courts come in after sometimes, often actually, like once the protest is over, people are let go, and it's harder to actually get this challenge in court, or you can, but it's more of an uphill climb. So a lot of this diffuse decision making in that context is problematic, especially when you have really vague provisions that are going to be decided on the ground. And I think there's a lot of elements of this in many of the other bills. So in C12, we have this provision that Karen was talking about that will allow for mass cancellation of documents for anything that the minister thinks is in the public interest, and with no guidance on what that could mean. It's literally open to the minister's discretion to decide. And, the minister is saying, oh, again, like we have these examples, like what if there's an emergency, but nothing there, legislatively, you can really put limits in place for when emergencies are actually happening. If this is actually where the power is going to be used, but there is none of that here. It's just a very broad, open-ended discretion. And it's in C2 as well, right? We have Tim was talking about these powers of these police powers to demand sensitive information from various service providers without a court order. So that's going around one of the basic kind of restrictions that we have in place under our charter, which is that you need authorization from a court before you get intrusive information. And there's an entire regime in Bill C2 that's being proposed that would allow the government, again, by ministerial decree, and it's very open-ended, to require service providers to re-engineer their services to make surveillance easier. And this could have very far-reaching implications for all the tools that we're using that are fundamental to our participation in society these days. But these orders could be issued by essentially ministerial fiat in private, in secret often. We may never even hear about them. It's just a bad way of it. Really, I think, erodes democracy in a number of ways, because it limits so many opportunities for participation from external voices that might not agree with what particular decisions the government is making in a given instance.
Yeah,
And I think
I think I would add one more thing is that the around the questions of the kind of broad discretion that Tamir was raising, and the sort of these vague, big notions that like Rizwan was talking about what is fear according to who, and the same, for example, in C12, the mass cancellation of permits or documents in the public interest. Well, who is the public? Who is the public actually that the government is talking about? If it is people who do not have citizenship that they are targeting. So obviously, by virtue of that, they mean not people who don't have citizenship. So the public is a very specific, highly racialized category in a lot of, especially in C9 and in C12. In terms of who is considered to be at risk and who is considered to be the risk maker. And I think that that's a really a thing that we, again, like I said, the reason why, for example, C12 was pulled out as being able to be fast-tracked and more easily fast-tracked. I mean, I think this is something that we need to be really concerned about in this political moment that we're in right now, where we are seeing an ascension of a far-right politics that is moving the whole kind of, what they call the Overton window. It's moving the whole space of what is legitimate dialogue way over to the right, and who fits there and who has rights there and who does not, is it becoming an increasingly narrow space. And in particular, in the last few years, with the level of scapegoating of migrants that has been taking place around, the housing crisis, the affordability crisis, youth unemployment, all things that are not actually based in fact. The introduction of a piece of legislation that says we also want to have more power to strip away the rights of all of these people based on who they are, which I think gets back to this charter question, right? Like it is actually like the C12. And I think, as Rizwan explained so clearly, the way that C9 can be used in the same way, with intent that can so easily be or if not overtly is discriminatory. Like that is the intention of being able to give the government the level of power to be able to say that for entire groups of people, or that the way somebody feels is enough to then put in jeopardy the rights and the livelihoods and the equality of an entire group of people, or of an individual. That those things I think are really raise concerns about like the charter compliance for sure. We had the Safe Third Country Agreement has been challenged in the courts. The designated country of origin list, which was when the government said we won't take asylum claims from these countries, period. That was also ruled in violation of the charter by the federal court in 2015. Like there's a real basis for all of these things. Some of the powers, some of the mass cancellation powers in C12 actually harken back to the 1930s. And one of the really salient examples is the turning away of the MV St. Louis, that was a boat of Jews fleeing Nazi Germany. That was an example of the government saying, we don't want entire groups of people coming here. End of story. Japanese internment. Like there's many, many examples of what we now look back on and say we're overtly racist, overtly discriminatory, and we're in violation of the charter. And in some cases, were the reason for the development of the charter. Like to protect some of these grounds. And then now we are seeing all of these pieces of legislation that kind of want to just walk a lot of that back.
Yeah. I did a lot of work in international free expression work in declining democracies in the past. And I think a key theme that we see there is that broad powers with kind of a fluffy motivation, but with no safeguards on them, will not be used exclusively for the nice thing that the government claims they're for. They will be used for what people in power want them to be used for. And I think in this case, we can easily see these very broad powers being pivoted to invade people's privacy, to deny people, whole groups of people, classes of rights, kind of things that might seem unreasonable, even to some of the people in government today. But 10 years from now, 15 years from now, maybe even 5 years from now, a different government might look at those powers and use them quite differently.
Mm-hmm.
So going back, I guess, to the particulars on these particular pieces of legislation, is there anything salvageable here, do we think? If we do a quick go around on these different bills, on Bill C8, do we think that there's something worth retrieving that the government should consider doing there?
I do actually think C8 in particular has like the objective of C8 can work, and there are elements of it that could work, but it really needs like a framework that doesn't allow it to be used just to facilitate what's effectively going to be mass surveillance, or to allow like really intrusive searches of people's private internet traffic. Are we doing one by one, or
yeah, I think let's do bill by bill. We can.
Okay, so I do think C8 is salvageable, but it really does need some fixes. Like there are some very fundamental flaws at the heart of this bill, and it was just adopted with this mistaken assumption about how it could be used that hasn't been corrected. So
yeah, I think I agree with you. It could pass in a salvageable form, but I worry that it essentially did pass. It's only on a technicality that C26 was stopped previously. So if it works its way through the system all the way like C26 done, it's still going to be extremely broken. Any other views on a C8 though? Let's talk about C9. What do people think about C9? Something worth saving?
Maybe I can start, and I'd love to hear if anybody has other views. I think this is a really tough one. We know that there are other civil liberties leaders in the country analyzing this and who see it as fatally flawed. From our perspective, that section 2.2C that uses this resemblance, confusion language, all of that around hate and terror symbols, if that language stays in the bill, for us, that's a poison pill. That will make the bill unsalvageable. So the first thing that would have to be done is to remove that language from 2.2C, that nearly resembles language entirely. If what we would like to see is, I think there's other aspects of the bill that could be potentially salvageable. If there was some more safeguards, to some more checks and balances in there. But I think realistically, like this is so complex and it's so important to get right that, we think that halting the passage of the bill until there could be proper consultation that have like with impacted communities, that would be something necessary to do. It couldn't just be, a few groups kind of validating and a few groups opposing. This needs broader consultation because it has the potential to impact many Canadians broadly.
I'm just going to jump in briefly on that. I think one of our concerns with CCLA's concerns with C9 in particular, and why we think it is fairly fundamentally flawed, or should at the very least kind of go back to the drawing board and receive some more consideration, is also just I think part of the problems that it's purporting to address are things that could actually be addressed with existing powers. So there's just there's a little bit of a disconnect between how existing powers are used when there is discretion on the ground and how to use them, and how these ramped up powers are going to be used. And that's a concern for us, and particularly a concern that they're going to be used in ways that are discriminatory and will impact particular groups in ways that are actually discriminatory. So for us, that's one of the concerns. And one of the reasons why we think this one is fairly fundamentally flawed.
Yeah, we're kind of in the same vein as Tamir, and I think Rizwan put it really well. This idea of like a poison pill, and I don't think this applies just to C9. It's like that there are some areas in these pieces of legislation that maybe are very specific, that could be that groups have been calling for, that could actually address, or with again serious debate and changes, could address real problems, but that they're caked inside these bills that have so many other problems that you can't actually fathom, and we would never be able to amend the bills and get them fixed to the degree where we could support them being passed. So even if there's an agreement that more needs to be done to address hate crimes in Canada, the fact that there's these sections and we would say that the parts on intimidation and obstruction, as well as the terrorist symbol sections, just can't be amended to be able to properly address it. So that even if the proposition of bringing in standalone hate crime offenses it's like that there could be rational disagreement around, but that is a plausible way of thinking about how do we address hate crimes in Canada. That it's so burdened by all these other parts of the bill that from our position we're simply against the actual the passage of this bill, because the government isn't open to the changes that are needed, haven't done the consultations, and that the risks are simply way too big to say that if you fixed X part of the bill, then we think it could be that we think it could be salvaged. Yeah.
I would. I mean, a lot of the folks here know how I feel about trying to salvage the bill. I've been beating this like a drum. That with C12, we definitely like our position, and in terms of the Migrant Rights Network, I'm here as Migrant Workers Alliance for Change, but we are the spokespeople for the national network, and our position would definitely be that it's not salvageable at all, precisely because on the one hand, like what folks have been saying, like a lot of these powers that are in there already exist. So why this extra kind of supercharged version of it? And also because they are like, where are these things coming from? So I guess in three different ways. So if these powers already exist, why supercharge them? And the other piece is that they pose the risk of being able to, broadly discriminate against groups of people, being in violation of the charter, for example, in the case of C12, like flagrantly going against Canada's international refugee obligations and what exists in international refugee law, like, so really going against the grain in terms of like what is established as like basic legal kind of minimums around these things. And then the third piece is, where are these things coming from? Like why and why now? And I think that's a key piece that is maybe another unifying factor across all of these bills, is like why and why now? And I think with C9, that is the question that, I mean, now I'm wearing my, like me, just as an individual and my things I spend the rest of my time doing, is like, why now? And why now? What is the motivation behind some of these things? And I think for that, we have to understand kind of like the political balance of forces in this government, right? Like we have a barely minority liberal government. you know, tanking in like liberal fortunes from the previous government. We have an ascendant, like conservative, much more far right. We have a decimated NDP. Like, so what's happening out there politically in terms of like the electoral landscape? And I think we have to ask ourselves questions about what are the moves that the government is making to try and shore up the places where they are strong, or to try and shut out the places where they are weak. And so to me, that analysis really kind of blows open C9 and those pieces to say this is actually not necessarily about like fear and hate symbols, and it is actually about an ascendant movement in solidarity with Palestine that has been very specifically and clearly naming Canadian government the violations of international law, violations of the Armed Treaty, and violations of Canadian government complicity, and the kind of like the contradiction and crisis that has. So that's the why, I think, very clearly when you look at it as like what is happening in the world right now and what is happening in this country right now and where are people positioned in respect to that. So in terms of C12, for us, that's the other concern, right? Is there's no way that in this climate, any government, no matter the political stripe, can do something to change the immigration system and pretend like it is not being motivated by xenophobia and anti-migrant racism. There is no way. And so partly on the basis of that is where our position came from to say it's not fixable because it didn't need to be fixed. These things that this bill says it's going to fix, it's not actually fixing. For example, I'll use as a very brief example, the closing of the 14-day exemption on the safe third country agreement for people crossing the land border between the US and Canada. The government has said C12 is about appeasing Trump and the tariffs and the fentanyl crisis and migrants crossing into the US. Well, the fentanyl crisis, crisis is a crisis, but in terms of cross-border flows from Canada into the US, they're basically negligible. So it's not grounded in fact. And the changes that C12 proposes doesn't do anything to stop Canadians from going into the US, but does everything to stop refugees from the US coming into Canada. So it doesn't actually fix the problem they say it's going to fix, which really begs the question, why? What's really behind it? So that was a long way of saying, no, it can't be fixed.
Yeah, just really quickly, I think that why now question is really, really salient. And we can see by the way that certain laws are being enforced right now, how these ramped up powers are going to be used. And that's a deep problem. And I just want to, I think with C2, which is the one, I think with C2, there's a similar problem there. Like you can, with so much attention being paid to rolling back, what was at least seen by some as Canada's welcoming posture towards migrants and immigrants. There's a real concern that these expanded surveillance powers are going to be used again to go after migrants, and like the fact that this is going to be used against people who are already, or already facing, real, systemic problems in society and just make their lives even worse, is a significant concern there. And then with C2 as well, like there are some powers, police powers that don't, in that bill that are relatively innocuous or would almost make sense. But again, like there's just a dramatic overreach at almost every stage of the bill. And I think that's part of why it's such a problem. Like, I think the government, to the degree that with C2 at least, putting aside the immigration parts, because those are very, even more fundamentally flawed, I would say, to the degree that the government's trying to address some, some legitimate challenges it's facing in its investigative framework, or to do things that are defensible, it just overreaches at every step of this bill. So I think that again is a problem of like, and how do we get to like, how do we fix something like that? That is such an overreach at every step of the process. Yeah.
Okay, I've got to move us on because I'm hearing we have a ton of great questions from the audience. But I'm just going to cap us with a few things. I want to let people know that every single organization here has some open actions you can take to be heard by politicians around this. I think in the after documents for this session, something's going to be circulated that you can look at to see that, but you can also just go to our websites right now. I also am going to do one quick go around because people often say, you folk just say no to everything, what's something the government should do. So I want you each to give me one thing the government should be doing. I just want 1 to 2 sentences, please. And I'll start with you, Tim.
Oh my God, something they should be doing. That's a good question. I think that that right now we're seeing some really important problems with how the Canada is implementing its counter-terrorist financing and proceeds of crime money laundering act. That's really undermining civil society. So it doesn't impact, it's not in these bills in particular, but they are, looking at these bills at the proceeds of crime money laundering and terrorist financing act in C2. Making all kinds of changes, but the one thing that they're not addressing is the fact that it's being used in discriminatory ways to target humanitarian organizations, to target Muslim-led organizations and others in racialized communities. So I think what they could be doing is looking at, how to address that and how to actually improve and support civic space and improve the ability for individuals to, both participate in their communities, but also, protect and help their neighbors, and also, provide aid and solidarity internationally. But they're, that they haven't done that.
Same question, but shorter. Karen.
The government, the immigration system that we have is a two-tiered system. Some people can only have temporary status, and that means that they don't have full rights. C12 is a move into making the precarious and limited rights that temporary migrants have even more limited. And so we would say they need to be going in the opposite direction, and that betting on full equality for all people, regardless of where they come from, means giving people full permanent status so that people can access all of the same rights that Canadians have.
Love that. Rizwan, same question.
Yeah, C9 purports to combat hate. If the government wants to combat hate seriously, they should expand funding for education and prevention programs that counter hate before it becomes violence, support Canadians that are working to achieve safety for each other, not from censorship, but from building understanding.
I love that too. And you, Tamir.
Okay, I have four, but I'll do them quick. So one is the Safe Third Country Agreement needs a very, very rapid revisiting, because what's happening in the US to refugees is untenable, and we shouldn't be, we're becoming complicit by turning people back into the asylum system in the US right now. We drastically need to update our Federal Privacy Act, which is a piece of legislation that was drafted in like the late 70s and hasn't really been updated since. Police are constantly talking about the need for new policing powers. Like this law is like the main law for privacy at the federal level, and it applies to the law enforcement and the government, but it hasn't been updated in decades, and it's massively outdated. We really need a framework for AI. The government is going full in on AI and adopting it at a rapid rate, but there's no regulatory framework in place, really, no meaningful one. And we need one. And then on the private sector, we need both to update our private sector privacy law, which is less outdated, but really needs some tweaks, as well as to put in, again, as well, some safeguards for AI, because again, like the private sector is also making use of AI in really expanded ways, and the technology is very problematic and leads to a lot of harms on the ground for people across the board.
Okay, I agree with all of that, and I would also say, it is possible to regulate some of the worst harms on the internet without impinging on rights. We fought really hard with the government to do that, and we would like to see them pass legislation that actually does it. So we're going to take questions now. Let's get the first one, and they're going to be fed to me. So just one sec, and I will read this question out.
That's all right, Matt, I'll read it out. So the first question is from Eric, and Eric asks, why is it that the Crown sees the Charter as an obstacle to overcome and not a treasure to protect?
Huge question. Who wants to take a stab on that one?
I'll say one thing. It's definitely been the case for the last, this wasn't always the case, but increasingly you see the government introducing legislation that pushes back against the Charter, but never really introducing safeguards that would enhance things that are protected by the Charter. Like, you just don't see it anymore. And this used to happen more historically, but it's just not the case anymore. So it's an unfortunate, it doesn't answer the why, but it's an unfortunate reality that we're dealing with these days.
I would add also that we need to keep thinking about fear and speed. So we all talked about how fast the government is moving to develop legislation, push it through the House, very limited time spent studying it at committee, and kind of rushing it into law, and then you run into all kinds of problems. I think part of that is responding to fear. So in the case of hate and combating hate, we've seen spikes in hate crimes and hate incidents targeting many different Canadians, some of whom we mentioned previously. And when the government is under pressure to respond to an emerging pattern that is getting more and more lethal, especially in the case of Muslims, for example, um, you can see why they might kind of say, well, we need to get the balance right between upholding the charter and promoting safety. But then when you go too fast and you're responding to something that seems like an emergency, there is a risk of overcorrecting and going too far the other way to say, we are going to sacrifice rights in favor of safety. We need to save lives, and that's a false dilemma. There is a balance that can be struck, and like some of the other people that are on this panel have spoken about, when there has been more consultation, when there has been more deliberation, when, as Tamir just mentioned, there's more thought put into what are the safeguards that are relevant and effective. When there's jurisdictional, sort of comparative study to see what's working somewhere else, what's Canada's unique context, what do we need to do here? There's a lot more that we can do to uphold the charter than to pay it lip service, which is, I think, maybe I'm being a little unfair. I meet people, I'm sure, in government and policymaking and developing legislation who are sincere in their claims to want to uphold the charter. They would agree they see it as a treasure. But in practice, when you're dealing with fear, you're dealing with speed, you're dealing with, you haven't consulted enough, these kinds of things I think can happen more and more and more. And also, I'll just add, Karen spoke about sort of the political landscape and how that's changing and how we're seeing more authoritarian movements and more extreme politics, more polarization. That also leads to undermining democratic processes. So that, we were talking about this as a group before we came on, and Jim was even referring to, like, what happens to the democratic process at committee when people seem to just turn it into theater to make clips for their future campaigns, or to engage their base in something. And I think we see this happen more and more and too much, and that can't lead to good public policy. It just can't.
I'll say something that sounds like a joke, but I mean, it is really inconvenient for the government to respect rights, and it's much faster to just sweep things aside and quote unquote get something done. I think a lot of well-intentioned lawmakers try to get around the court system because they can get something done faster outside it and keep rediscovering why it's important to have a checks and balances system.
Yeah, Tamir, you should go ahead.
I was gonna say really briefly along that same line. I think also governments often are like, well, we're not going to misuse this power, so they don't want to put checks on their own use. But that's just not how things play out down the road. Like in a year, even the same government facing a crisis is going to make different decisions, like Brazil was just saying, or another government may make other choices. Like you just can't do legislation that way. But it's almost understandable why a government official who's sitting there thinking like, how am I going to use this power? It's not going to be like, well, I'm going to abuse it, right? So I think that's an endemic problem with legislative drafting, and why they need to hear more from the people who are affected by the legislation that they're putting out.
Or at all, as the case may be.
Or at all.
Let's take the next one, Ange.
The next question, an attendee asks, they say, you have talked about how there are common concerns across this whole series of government bills. Could the panel give examples how each puts Canadians' privacy at risk?
Sure. At least two of them break encryption. So Bill C8 and Bill C2, there's some text that pretends that it doesn't. Both of them do, in effect, break encryption. Maybe someone else can speak to the C12 law enforcement info sharing aspect.
Yeah, in C12, I would say I would maybe put the question back and say, it's not just the privacy of Canadians, but the privacy of anyone who is living in this country, whether or not they're Canadian. And the way that C12 does that is by empowering the immigration department basically to be able to share immigration and personal identity information with lower levels of government, but that includes policing agencies, with like provincial or municipal policing agencies. It can include, like we said, any crown corporation, so they could be sharing that information with any kind of like municipal housing authority or what have you. And so then you find out that your landlord might be learning things about your immigration application or your family that you're trying to sponsor, that your landlord really has no business knowing about. And so in the same way that those kinds of information would impact someone who has citizenship, they impact somebody who doesn't have citizenship in the same way in terms of privacy, but doubly because it is mitigated by and it interacts with their immigration status, which is the linchpin that allows people to access or to not access all of the other rights, right? So when it's maybe not safe to call the police if there's violence in your home because you're worried about what they'll do to you or who they'll share that with, if you have an immigration application in course, for example. So there's all these other things that get made worse by the fact of someone's immigration status and the precarity that brings to a person.
If I can jump in about Bill C2 and just, we mentioned the question about encryption, but this lawful access parts and the idea of lawful access, which is basically giving law enforcement an easier access to our personal information, really fundamentally threatens privacy. So this idea that, as I mentioned, Tamir mentioned that, law enforcement, just on the idea that the information could assist, that they have reasonable grounds to suspect, which is very low, that information could assist with the investigation of offense that's being committed or could be committed, that they could go to your bank or to your therapist or to your doctor or to apps that you use for private purposes like dating apps or things like that, and say, does Tim McSorley, come to you for therapy? Yes or no? Do you provide them with services? And then, okay, if you did, when did they start, availing them of your services? Where do they avail them from? Do you hold on to any information about any other services that, Tim McSorley can access? That's highly, highly revealing and really fundamentally, has privacy implications. But the government is trying to frame it as saying, well, it's just simple yes or no questions, and that won't actually have an impact. And then building on it, they have these new low threshold warrant powers. They'd have to see a judge, but again, it's on the basis of reasonable grounds to suspect that it could assist with an investigation to then find out, well, okay, so what other information do you have in your files about, this person's access or use of your services? And by the way, can you tell us exactly what other services you may have referred them to? And so there's just some, there's other aspects too. I know we have other questions, but, it has a fundamental, there's fundamental privacy implications. And this isn't, again, as we've said, not just about the border. And the government's been clear about this. This isn't just, you can only use it if you're investigating fentanyl trafficking or something like that. It could be used for any investigation of any act of parliament. And so it raises some really, really fundamental concerns. And then on top of it, there's this whole question about creating reciprocal powers for foreign law enforcement to have their requests enforced. Groups that are fighting for reproductive and sexual rights have said that, for example, an American who comes to Canada or avails themselves of services in Canada for reproductive health purposes, that's illegal in their state in the United States. That if their police there are investigating this, they could then, ask Canada to enforce their their request for information and share for them to be prosecuted in another state. So it's just unbelievable that, that this is being allowed to pass and being promoted under this idea of we're protecting the border, when really it has, I think we just question, is the border really that bad, in the first place? That in itself is an issue, but then that this is completely unrelated to that question.
Yeah, we can all go really deep on C2. So for additional resources on C2, check the package that'll go around afterwards. But Ange, next question.
Yeah, the next question is from Dom. And Dom says the judiciary is supposed to be the check on legislative and executive branch. Couldn't your various organizations get together and launch a charter challenge on behalf of Canadians on each of these once they become law? Couldn't you make the argument that Section 1 would limit the government scope, minimize harm to rights, and apply the Oakes test, etc.? And couldn't you further try to link the harms to the charter rights beyond the scope of notwithstanding clause as well as guard against that as well?
Yes, but they shouldn't pass legislation that's not going to pass a charter challenge. They should try to pass legislation that's compliant. But
Yeah, I think that's right. Not just charter compliant, but we should be doing good public policy when we're drafting legislation. But even aside from that, a lot of these legislation, like elements of them are surely unconstitutional, and the courts will sort that out. But there's also a lot of like pragmatic barriers to advancing challenges to many of these laws. Take C8, which is the cybersecurity regime that Matt was talking about. And Bill C2, there's a regime that Tim and Matt and others are talking about that could require people to re-engineer the services to re-engineer their services to make surveillance easier. A lot of that's going to be happening in secret, so it's very hard to interject and into that process and make the charter challenge you need to. And then other provisions like the information demands that Tim was talking about, where police can just demand information from service providers to confirm if someone is a customer of theirs. The way that those are framed is the service provider, like there's secrecy around them, so the person impacted by the order never finds out. The service provider has 5 days to challenge it in court, or they're could potentially face stiff penalties. So it's really difficult to get some of these before the courts in ways that can really actually address some of the flaws. And I imagine C12 has many of these as well, not to prod Karen, but and C9 as well. C9 as well, like when it's being applied on the ground by law enforcement, right? You could eventually challenge those decisions in court for sure, but a lot of the harm could already pass by that time.
Yeah, I would just say that it's court challenges, yes, are, an important kind of part of the ecosystem, but they take so long and they take so many resources. And for a lot of these bills, the people who are going to be the most impacted by them, those impacts are immediate, and will be immediate, and in some case for tens of thousands, hundreds of thousands of people, and those impacts can be devastating, right? So in the case of any of the immigration provisions and the information sharing, whether it's C2 or C12 with respect to that, those are, people can be long deported by the time a charter challenge is heard to say that they shouldn't have been.
Yeah, I think another thing I would just add, building on what others are saying, is that when you think about the political landscape and the economic landscape and court challenges in that landscape coming from civil society organizations that rely on everyday Canadians to support them, especially small donations coming from all across our communities. And you think about the affordability crisis, the housing insecurity crisis, the food security crisis that so many Canadians are dealing with. So many Canadians are carrying large consumer debt, personal debts. And so in the midst of that, Canadians are still also trying to give to charities and to nonprofits that do good things, and to civil society organizations that stand up for Canadians' fundamental freedoms. But in the midst of all of that, if on top of everything, we have to start launching charter challenges more and more, this is so expensive. And it takes so much time. And in the midst of that, if we're putting that burden on everyday Canadians, I think that's something for us to sort of account for in all of this. Also, another thing about the political landscape, what we see south of the border in the US is a president and a federal administration that's has an approach to legislating in a way that where they kind of are extremely hostile to the courts, to the judiciary. And they even talk about it in terms of we're going to war on the courts. And, because we want to bring democracy back. And I think this is a kind of populist politics and an extreme populist politics that is seeping into Canada. It's here. And I've heard elected officials, sitting MPs, say off the record, if we have the chance to, we want to go to war against the courts. And when you ask them why do you think you need to do that, they'll say, well, to get our agenda through, we need to invoke things like the notwithstanding clause and other kinds of things, because otherwise the courts just strike things down that we need to do for the betterment of Canadians. And so they're making arguments at the grassroots about why they need to do things, but a lot of times those arguments lack specificity. They're not giving people the full context, the full picture of what this means. So a lot of times we find people being pushed into voting against their interests. And so if in the midst of all of that, our solution is to launch charter challenges, I think we're kind of not getting at the root of the problem. But I think if other people have other ideas, I'm open to ideas at this point.
Not on this question, they don't. We have time for one last question. So, and just one more, please.
Yeah, and the next question, an attendee says, you've talked about the removal of the Attorney General's consent to hate speech charges. What is Attorney General's consent and why is it important?
Oh, is there a lawyer here that can speak to that? I'm not a lawyer. I can speak to that though.
I think, well, just very briefly, like for hate propaganda charges, the attorney, so for in general, charges are brought by prosecutors at the provincial level, and there's a lot of them, and they have a lot of discretion when they can bring charges against people. For specific crimes that have the potential to really kind of impact on freedom of expression, like the hate propaganda offenses, you need consent from the Attorney General, which will give it a much more deliberate kind of consideration before the charges go forward, basically. But I think the actual context of this, Riz, you could probably speak to a bit more in terms of like what it means on the ground.
I think in the interest of time, I won't add more to that. I think that's a really good answer.
So I will say this: the risk of politicized prosecutions being brought forward against like an issue that like a cost level of the day goes up significantly higher when you don't need approval from the Attorney General. That's particularly problematic when you're talking about peaceful political protests, like Karen mentioned, the Palestine Solidarity Movement that's been experiencing a lot of pressure in terms of protests lately. But there's many others, and it's really going to change based on whatever the political issue of the day that's like got people worked up, and that's the risk. There's a really heightened risk of politicization when you remove the Attorney General's consent.
I fully agree, Tamir. Thanks for that.
Being charged with hate speech has huge reputational consequences, even if the charges were never going to be confirmed. So just keeping the bar high for frivolous cases is important. All right, back to you, Jim, for closing us out.
Well, thank you. I want to thank the panel for a really engaging discussion. I mean, you had to cover an enormous amount of material in a very short period, but I think you brought all of it together in a useful way. And I want to thank the audience for your engagement and for your questions. And I want to say that tomorrow morning we're going to post a video of this. So if those of you who've seen it would like to draw it to the attention of colleagues or friends or people in your network, the link, you can go to the CFE website, which is cfe.torontomu.ca, and you'll find it there. And as Matt indicated too, along with the video, we post some additional readings and resources. So there'll be links to all the groups on here and various actions they're taking. There'll be material related to some of the things we discussed tonight, so that if you want to dig deeper into any of these issues, look at that list of additional readings and resources that will be posted along with the video. Our next event is going to be 2 weeks from tomorrow. It's going to be on Wednesday, December 10th. And in some ways, it's going to carry on a little bit of what Rizwan was just mentioning. It's going to focus, the title is The Charter of Rights and Freedoms Notwithstanding Clause and the Future of Canadian Democracy. Now, the Charter of Rights and Freedoms, as you know, made Canada a constitutional democracy in which unelected courts, not elected legislatures, have the final say about rights and freedoms. Yet that was controversial at the time, and so there was the assistance of adding the Section 33 to the Charter, which is called the Notwithstanding Clause, which was built in to let governments override the courts on certain matters. Now, at the time it was introduced, the clause was very contentious, but everyone was assured this is a theoretical protection that maybe never will have to be used, or may only very rarely ever be used. And what we've been seeing since, and especially now, is that it's being increasingly invoked to deny democratic freedoms and human rights. We hope you will join a panel of some of the leading legal experts in Canada who've thought a lot about what do we do in this circumstance where amending the charter is probably just not a possibility in any of our lifetimes. But how do we protect rights when they now look like they're going to be cavalierly overridden by various provincial governments? And what does this mean for the future of Canadian democracy? Our panelists are going to be Eric Adams, who's written and thought a lot about this. He's from the Faculty of Law at the University of Alberta. Aeneas McNichol, who was going to be with us tonight in Canada, the director of the Fundamental Freedoms Program at the Canadian Civil Liberties Association. And Richard Moon, who's one of the distinguished constitutional law professors, professor emeritus of law at the University of Windsor, will be our panel looking at this. So I hope you can join us in 2 weeks. In the meantime, please check our website, cfe.torontomu.ca, where you'll find a list of all the upcoming events, as well as links to videos of preceding ones. Thank you very much for joining us tonight. And again, thank you to the panel.
Thanks so much for hosting us.
Thank you.
Thanks, everybody.